Yo, it's your boy Jacob. Tonight we're going over the alternative writ of Mandamus given to us by Honorable Judge Christy Horman in Freeborn County. Right away, let's explain the difference between this alternative writ and the preemptory writ. The preemptory one would have been the court compelling the city to essentially grant my registration without any opportunity to argue against it, whereas the alternative writ essentially gives them the ability to respond with why they feel what they did is right, and what they did is, in my opinion, violates state law and their own city ordinances. Frankly, it's going to be interesting to see how the upcoming dismissal hearing goes, because their motion to dismiss is purely based on this writ of mandamus being outside of the jurisdiction of the district judge and nothing more. Again, you can't forget that lawyers can't really help their clients break a law or facilitate their clients committing a crime. So a motion to dismiss is kind of all they have to rely on, other than just outright delaying things as much as possible, which is something I also expect. And don't forget, you're a lawyer defending their client's right to a fair trial is definitely different than defending their client who is guilty and trying to get them to magically be innocent. If you broke the law, you broke the law. You can't just magically not have broken the law unless something went wrong in terms of how a case was handled, or you are a really good criminal. Or I guess if you're a politician like this, hey, shout out to the Albert Lea City. In my opinion, you're all a bunch of criminals. Anyways, let's just dig into everything, and let's give a shout out to the shirt. This is one of the designs I made when I was the apparel head for the international Tommy Chong brand. It's Tommy smoking a joint. We got the cannabis mistletoe up here. We got the peppermint patterned joint paper. He's ho-ho-hoing and coughing because he smoked too much. It's a cool little design. We might have some left over on the Get Slicks website, getslicks.com. Anyways, let me minimize the camera and we can dive right in. So this is just your basic header. We got a case file number. You can give that to your lawyer if you're in a similar issue. Again, the whole intent behind these videos is to help out other people in these issues and maybe save them some time and effort and money by giving them a resource, a tool to use to hopefully lessen the suffering they go through. So this basically says this matter came before Honorable Judge Horman on September 17th, and just some basic background, who the attorneys are, who the parties are, the date I filed the petition, September 8th. Petitioners requested the court grant a preemptory writ of mandamus requiring respondents to issue the retail registration to petitioners as applied for, or in the alternative, grant an alternative writ of mandamus requiring respondents to show cause as why they feel they do not need to issue the registration. And then additionally, we're seeking various damages, attorney fees, costs, etc. We argue that the Albert Lea City Ordinance 5.029 creates an exclusive list of reasons the City of Albert Lea may deny or revoke a registration, and on 5.030 imposes the duty upon the City of Albert Lea to register cannabis businesses on a first-come, first-served basis based on that time-stamped state of Minnesota OCM-issued license, which was held up by me in the first video. September 9th, the city respondents filed a responsive letter memorandum with the court in which they requested the court dismiss the matter, thus denying a preemptory writ of mandamus, or in the alternative, issue an alternative writ only. Respondents argue the court should deny and dismiss petitioners' request for mandamus relief because the court lacks subject matter jurisdiction to issue any writ of mandamus. Respondents hold that because petitioners have obtained a writ of certiorari to challenge the City Council's decision from the Minnesota Court of Appeals, petitioners have adequate remedy at law. I disagree personally, and we'll get into that. Thus, petitioner has an adequate remedy at law, and this court lacks jurisdiction to issue a valid writ in the absence of a justiciable controversy. This is where it gets juicy. The findings and conclusions made by Honorable Judge Horman, shout out to her, based on the files, records, and proceedings here in the court, makes the following findings of fact. July 17th, I was issued my state license. Same day I applied for the city registration. July 28th, the application went before the city council. Also July 28th, at the city council meeting, the respondents, the city of Albert Lea and city council of Albert Lea, did not discuss the application on its own merits, but rather denied the motion to grant my application for a cannabis retail business registration based solely on council members' policy disagreement with the state law and city ordinance that required that issuance of the registration. Now, we pay our taxes for them to do their jobs, not make shit up on the fly like that. So yeah, that's crazy. Let's let that paragraph marinate in our brains. Think about how crazy that is. Carrying on. Respondents were required by state law and their own ordinance to issue petitioner's registration, as petitioner's application had first priority under the ordinances 5.030, and I had met all the requirements enumerated in MnStat 342.22. Section 5.023 of the city ordinances describe the obligation to issue the registration and describes the application procedure below. This is nothing new. We showed this in video 1. Carrying on, the second provision of the city ordinances, 5.030, describes the city's obligation to register cannabis businesses. It says right here, first come, first serve. We went over that in video 1 again. This is pretty redundant. It does get a little bit more juicier as we go on. Petitioners also cite MnStat 342.22, which provides a local unit of government shall issue the registration. Again, we went over this previously. And the final one, petitioners ask the court for a preemptory writ requiring respondents to issue a cannabis retail registration to petitioner as applied for, or an alternative writ requiring respondents to show cause why they were not required to issue the cannabis retail business registration as applied for. So here are the conclusions of law, and these are the conclusions that need to be made to determine whether or not a writ of mandamus is applicable and a possible avenue for us to go down here. 1, mandamus is an extraordinary legal remedy. 2, the district court's authority to issue a writ of mandamus is statutory. 3, the two primary uses of mandamus are 1, to compel the performance of an official duty clearly imposed by law, both the Minnesota statute and city ordinances. 2, to compel the exercise of discretion when that exercise is required by law. Now, that's a very important sentence, or I should say part of the sentence right there. The court can't tell the city council or whoever would be the defendant in whatever mandamus writ someone brings up. They can't tell them how to exercise their discretion. They can just tell them to, get back to someone. If you came to me and you're like, Jacob, what's your favorite color? And I ignore you and move on to the next question. This is all an example. And then you brought a writ of mandamus against me to compel me to exercise my discretion. That would just mean I would have to answer you. It doesn't mean the court can tell me how to answer and tell me what color to say. Does that make sense? Now, the other important thing, and this is what blurs the line between the two writs we filed, is that basically how tightly written the state law and their own city ordinances are. Their discretion really would only end in one way, which is me getting that registration. So do they really have discretion? Technically, yes, but not really. Which is really just a no then, right? I'm not a lawyer though, but that's how I see it. Continuing on, number 4, even so, I need some water. Excuse me. Number 4, even so, a writ of mandamus does not control the particular matter in which a duty is to be performed. Kind of what I just said. And does not dictate how discretion is to be exercised. Again, what I just said. 5, when presented with a petition for a writ of mandamus, a court first reviews the petition to decide whether to issue a writ and what form the writ should take. If the court issues it, the writ may be peremptory or alternative. 6, to obtain a writ of mandamus, a petitioner must show 1, that the defendant, in this case the city of Albert Lea, failed to perform an official duty clearly imposed by law, both the state law and the city law. That 2, as a result, the petitioner suffered a public wrong specifically injurious to the petitioner. And 3, that there is no other adequate legal remedy. Later on, the judge then clarifies her findings for these 3 points that must be shown. 7, the first requirement is met by demonstration by the petitioner that the existence of a legal right to the act demanded is so clear and complete as not to admit any reasonable controversy. So we're kind of going over the bar that has to be met to get a writ of mandamus and or alternative writ. 8, the court reviews the languages of ordinances in the same manner it reviews statutes. In doing so, the court looks to see if the language in an ordinance is clear and unambiguous. If the language is unambiguous, then we apply the plain language. Language in an ordinance is ambiguous only if it is subject to more than one reasonable interpretation. The word shall is mandatory, which is the judge's way of saying that it is unambiguous because, again, shall is mandatory. There was really only one course of action that the city should have taken, which is issuing my registration. That's how I'm interpreting that. 9, the court finds that the specific language of the Albert Lea City ordinances 5.023 and the Minnesota statute 342.22 mandate an issuance of retail registration. So that confirms what I just said. To a state licensed cannabis retail business that meets a certain set of requirements. Therefore, the city council's refusal to approve my application was a failure to perform an official duty clearly imposed by law. Very black and white, very essential. 10. The second factor requires the court to determine whether petitioners suffered a public wrong specifically injurious to the petitioners. The court concludes that the city council's refusal to approve petitioners' application injured petitioners because they were prevented from realizing revenue and profit expected from operating a business that sells cannabis. Let's let that marinate for a bit. 11. As to the third factor, the existence of an adequate alternative legal remedy that is equally as convenient, complete, beneficial, and effective, and sufficiently speedy to prevent material injury, precludes granting a writ of mandamus. 12. Respondents argue that because a writ of certiorari is an alternative legal remedy that petitioners have pursued, this court lacks jurisdiction to issue a writ of mandamus. However, district courts may have jurisdiction to adjudicate derivative claims so long as the resolution of such claims does not require inquiry into the validity of the quasi-judicial decision. If resolution of the claim does not depend If resolution of the claim does not depend on the validity of the quasi-judicial decision, then the party may raise the claim by filing an action in a district court. The presence of overlap is not enough. The claims themselves need not be completely separate and distinct for the district court to have jurisdiction over them. Further, under Weber, mere relationship to a quasi-judicial decision is not enough to preclude the assertions of claims in district court. 13. Keep yawning, excuse me. Based on the record before this court, it cannot be determined that the claims are completely separate and distinct. It is unclear to the court what relief petitioners are seeking through a writ of certiorari and whether that relief is identical to the relief sought through this writ of mandamus. It is unclear to the court, based on the petition, whether or not petitioners are challenging the process that respondents followed in making their decision is the violation, or if the decision itself is the violation. 14, the court does not have enough information to determine that petitioners have an adequate legal remedy outside the writ of mandamus to address respondents' failure to perform its legal duty. Again, I understand. Okay, the court, having considered the motions of the parties, the arguments of the parties, the file. I don't know why I'm yawning so much. It's not even that late. The file and all the records contained therein, and being fully advised in the matter, does now hereby make and find the following order. Petitioner's request for preemptory writ is denied. Petitioner's request for alternative writ is granted. Respondents, the city, are hereby ordered to issue a cannabis retail business registration pursuant to petitioner's July application for the same and make a return to this writ showing you have done so, or that respondents make a return to this writ pursuant to MnStat 586.06 within 21 days from the date of service hereof, showing cause before this court why it has not complied with its statutory duties owed and owing to petitioners. Then we just got a follow-up date in court, and then service shall be within 3 days, yada yada. Excuse me. And then we have the honorable judge's signature and date. So it's pretty black and white, pretty clear. Overall, the big question left on the table is whether or not the judge has jurisdiction. And, obviously, from my brief understanding of the matter, I'm not a lawyer. A writ of mandamus can't override an already made decision by a quasi-judicial body. But this might still have some legs, and I really can't go into why I believe that, just because the dismissal hearing has not happened yet. So I will follow up in another video. This video is purely meant to just kind of show the background and what goes into a writ of mandamus and the types of criteria that need to be met and what a judge would be looking for, so that if someone else does seek this as a way to hopefully defend themselves, they'll have a better understanding of what they're going through, what they're going to go through, and what they need to get a lawyer to deal with. As always, specifically for cannabis law, got to be careful. A lot of lawyers claim to be a cannabis lawyer. That does not mean they have experience with administrative and municipal law, which is actually what this would be. Now, the sub-niche of that would be cannabis law, because I'm a cannabis business. But as you've noticed, a lot of this is pretty black and white statutory bullshit we're dealing with, because the Minnesota Statute 342.22 is so black and white, and then as well the municipal ordinances with the city of Albert Lea. So hopefully that kind of gives you a better idea of what to search for if you are hiring a cannabis lawyer specifically. And in any other industry, I'd kind of say the same. Find yourselves a good administrative law firm, and you should be good to go. Don't be afraid to interview them and ask if they've won similar cases or not. So yeah, I think that's about everything. Like, sub, share, hit me up in the comments below with any other questions. I'll do my best to help out, and wish me luck. Based on this, though, this has me feeling pretty optimistic. And again, if you reach out to the city, be respectful. Or, better yet, run against them. Please. I don't care if you're left or right, if you're red, blue, or purple. It doesn't matter who you are, what your background is. Everyone has a goddamn right to start a business. We have the right to liberty, justice, and the pursuit of happiness, baby. And that means being an entrepreneur, starting a business, and trying to break the chains of wage slavery in America. And you're going to do that by usually being a business owner. And that's why it is so wrong and so important that we defend ourselves when our rights are violated and we're told we can't own a business, even though we followed every step and met every criteria set along the way. Thank you again for the time. Thank you for the support. Have a good night. Peace.